Without any further delay, as Michael said, we're really grateful that you guys came out tonight. I know we're into the time, a period where everyone gets busy between school and graduation and those things. So we hope this will be exciting for you. Stick with us. We are going to have an opportunity for the audience to ask questions at the end, and we're pretty excited. So if our debaters will go ahead and join us on the stage at this time, I'm going to begin introducing them. And as you can see with this topic, it was important that we get some of the best experts in Oklahoma about the issue of free speech. Our first debater that you may have seen listed on the program is Marc Blitz. He's the Allen Joseph Bennett Professor of Law at Oklahoma City University. His scholarship focuses on the First Amendment, free speech rights, privacy law, and Fourth Amendment rights against unreasonable searches and seizures. As many of you know, that's an issue going on right now, talking about civil asset forfeiture. Marc, his work has been published in the Texas Law Review, Wisconsin Law Review, Hastings Law Journal, and American University Law Review, Cardozo Law Review, and other journals. Please join me in welcoming Marc Blitz today. Next, we have Andrew Spiropoulos. He's the Robert S. Kerr Professor of Constitutional Law at Oklahoma City University School of Law and the Director of the school's Center for the Study of State Constitutional Law and Government. He is a graduate of Carleton College and received an MA in Political Science and his law degree from the University of Chicago. As many of you know, Andrew Spiropoulos actually served as the Speaker's policy advisor in the mid-2000s, and he has a weekly journal in the state's business paper, the Journal Record, called Right Thinking. Please join me in welcoming Andrew Spiropoulos. With that, we now have, and thus the water bottles, Professor Rick Tepker with us. He, as many of you have heard, his extensive work in this area. Hold on, I'm going to get the bio up right so I don't mess it up. Rick Tepker is the first member of the OU Law faculty to appear, argue, and win a case before the United States Supreme Court. In 1987, the court appointed Tepker as counsel for a petitioner. It was the first case in which an American court overturned a death sentence on constitutional grounds because the condemned was too young at the time of the crime. Professor Tepker has a passion for making sure that the law treats especially individuals in a just manner. So please join me in welcoming Rick Tepker. And then finally, my colleague, Trent England. He's the host of the MiddleGround radio show. And Trent, I don't want to mess up your bio either. Obviously, he serves as the Vice President of Strategic Initiatives at the Oklahoma Council of Public Affairs, and he's the David and Ann Brown Distinguished Fellow, and also serves as the Director for the Center for the Constitution of Freedom at OCPA and the Save Our States Project. He is also the National Coordinator for the Liberty Foundation of America and an Adjunct Fellow of the Freedom Foundation. Please join me in welcoming Trent. So the way our format is going to work, we're going to start with opening statements. Each of the debaters have been made aware that they have about 2.5 minutes. As you know, our chief topic or chief theme today is, does the First Amendment protect donor privacy? And obviously we want to foster a good discussion, so we have no intention to pigeonhole any of our debaters in their responses at all. And if you have a question about this issue or another towards the end, we'll open that up as well. So with that, I think I will go ahead and start with Marc, if that's okay, with kind of your opening statement or comment about this issue.
Okay, just because my name starts with B.
Yeah, that's it. That's good.
Well, first of all, a very simple answer to that question. Does the Constitution protect donor privacy, or perhaps more specifically, the right of donors to speak or to support speech anonymously? I think the answer is yes. Hopefully there'll still be a debate, because I'm suspecting that might be the same initial response from everyone. I won't get ahead of myself. And here's why, and then some qualifications, right? It protects it, but it doesn't protect it as staunchly as, or it doesn't protect the anonymity as staunchly as it protects the right to speak itself. And so here's why the simple answer is yes. For decades now, the Supreme Court has made clear that there's not simply a right to speak under the First Amendment. There is a right, at least in some circumstances, to speak anonymously. That is, to withhold your identity, or perhaps to speak pseudonymously, to use a pseudonym. But to speak in a way that you don't reveal your identity. Goes back at least to the 1960s. One of the leading cases is Tali versus California, where the court held there was a right to anonymous leafleting. And it harkened back to the Federalist Papers, right, which the authors published under the name Publius. A long history of Americans publishing, even in the framing era, leaflets pseudonymously. Those early cases often pointed out that if you don't allow people to speak anonymously or pseudonymously, sometimes they won't speak at all. They need that kind of protection in order to make their views heard. Otherwise, for a variety of reasons, the most serious being possible threats, violence, harassment, they won't speak at all. Now, things get more complicated in the modern era cases on anonymous speech, in part because anonymity can prevent audiences from getting information that in some circumstances they might need. And in part, and although my guess is our focus is on donors, well, that's not my guess. I know our focus is on donors, and our guess is that'll keep us closer to the extent we focus on the cases dealing with election disclosures. The question of anonymous speech arises in lots of other contexts where anonymity can not just prevent audiences from getting information they want, it can actually disguise some pretty awful action. There are lots of bad things you can do with speech. So I was talking about threats, harassment, reprisals as reasons why people might want to stay anonymous. Actually, though, anonymity can make possible threats, harassments, reprisals that wouldn't happen. So that's particularly true on the internet. There are lots of disputes about to what extent people should be able to shield their identity and make terrible comments about others, maybe even threatening comments about others on the internet, to what extent there should be technological answers to that, like that of the NSA. So in any case, things get more complicated. In the context of election-related speech, and we'll hopefully, before my 2 minutes are up, I'll work back to
well, I was just about
private
to say,
donations.
I was just about to say that I will give you a chance to hit that point.
Is that 2 minutes already?
It is. It is. But that's
no,
good.
I count only 20 seconds.
But that's
no,
exciting.
okay. So very briefly, then I'm going to just condense these, and then I'll come back to the rest of what I was going to say in the hour after that. In the context of election speech, despite the fact that the courts have said that they use something called exacting scrutiny, which sounds pretty tough on the government for any kind of compelled disclosure, they say they're applying exacting scrutiny. Then when they actually elaborate the test, it sounds like intermediate scrutiny. And by the time they get to applying it, it drops to minimal scrutiny. So the protection drops quite low. And that's not only from the court's liberals, that's from the court's conservatives. In fact, you want to cite a case that is in favor of allowing disclosure law. Citizens United is a good one to cite. How about private donations? Well, that's not, at least to my knowledge, it's not nearly as developed as donations in the context of an election, just a donation to a private organization. There was a week and a half ago a Ninth Circuit case that came down, the Center for Competitive Politics case, which basically just carried over the framework I just spoke about. Is that right? I think, despite the fact that there's got to be a right to speak anonymously, there are powerful reasons to suspend it. There are times, particularly when a decision has to be made and information is needed for the identity of certain speakers to be known. And I'll stop there.
Oh, good. And with that, we'll go to your colleague, Andrew Spiropoulos, for his opening statement. And please speak in the mic so that the folks watching us online will be able to hear as well.
Well, I am sorry about the people now listening online who can actually hear me. I I think we're all going to try to bend the space-time continuum in our own opening remarks. I'll try to, however, to stay within this universe if I can. But it's going to be difficult because I think we're all have a lot to say about this very important subject. I think that there is going to be a lot of consensus. We're all constitutional law practitioners and scholars, and I think that we're all going to accept that there's strong precedent, that there is some protection for anonymous speech. There is some protection for protection of donors, privacy. The question is how much? And the answer that I'm going to give is lots more than there has been to this point. It's got to be protected, to use Marc's word, much more staunchly than the court has been willing to protect up to this point. Why? I think that if you want to know the reasons, turn to Citizens United and Justice Thomas's separate opinion, where he is the only justice who talks about the importance of invalidating a lot of these disclosure provisions. And I confess, and I think if a lot of people are honest, they'll confess too, that many of us who agree with Justice Thomas, both on these principles and most of the time in his opinions, thought he had sort of gone off the deep end in this opinion, that he was alarmist, maybe a little bit on the extreme, because many of us believe, who think that both Buckley versus Vallejo, who started this whole line of precedent, and Citizens United are correct, that the key premise here is that when you spend money on politics, that is political speech. There is no difference between spending money and speaking. It's the same thing. Money is just the tool for speaking. Thomas agrees. We all agree on that. At least 5 of the justices now agree. So currently, 5 justices, including Thomas, agree that that is political speech. It gets the highest level of protection. You certainly can't limit what everyone calls independent expenditures. There is an exception for money you directly give to a candidate, but if you speak using an organization about your own political view, the government can't restrict that. But up to this point, with the exception of Justice Thomas, all of us on this side, what we want to call the pro-free speech side, that political speech ought to be robustly protected. We've all been willing to say, here's the deal. We need to protect all this speech. We need to be able to let people give as much money they want to speak as much as they want. More speech is better, but disclosure is great. And there's no problem if government just requires disclosure, because disclosure is transparency, and it's more speech. Let everybody see who's giving. Let everybody then can decide to weigh that any way they want. That's part of speech. And what Justice Thomas said in Citizens United is that, no, you cannot do that. You cannot ignore the principles that we've established in other cases regarding anonymous speech. They apply just as much to this context as they do to that one. And we said, oh, come on, let's just disclose, everything will be fine. More speech is better. And Justice Thomas said, no, look at what's going on right now in California regarding Proposition 8, the same-sex marriage initiative to protect traditional marriage. Look at what's happening to those donors in that state. Look at the threats that are being put against them. Look at the economic pressure. Look at everything that's going on. And he said, what's going on there is going to go on everywhere. The rest of us said, oh, you're just being alarmist. It's California, come on. They're just being weird. No. Look at what's happened in the last year. It's happening everywhere. He was absolutely right about the pressure tactics, the chilling effect being put on donors simply because they wrote a check to support a cause that they believe in. He was absolutely right. We need much more constitutional protection, much more robust protection of donor privacy than the Supreme Court has been willing to do to this point. Because if this really is political speech, if we really believe that, which the Supreme Court has said it should get the same protection as someone who wants to put an anonymous leaflet, which the Supreme Court has already said is protected by the Constitution. If that's protected, so should the contribution be protected as well. But Marc is also right. The devil is always in the details. For me, for example, and we'll talk about this as we go on, independent expector contributions absolutely have to be protected. That's pure political speech. Direct contributions to a candidate, that's different. I do think that disclosure requirements. But what about, for example, contributions to a political action committee, not directly to the candidate, but contributions used in speech to oppose or support a candidate. I now think those should be protected. If it's not given directly to a candidate, I think that falls on that side of the protection line. That would be new, and that's something I think we can argue about. But independent spectators, for me, is an easy case. And I just say one last thing. Why would Justice Thomas, we should have realized this, why would Justice Thomas be the one justice who could see through all this and understand it, right? Where did this principle in terms of protection and anonymity come from? NAACP versus Alabama, 1958, where the court said, compelled disclosure of the membership of the NAACP exposes members to economic reprisal, loss of employment. Ask the person who would have been CEO of Mozilla. Threatened physical coercion and general public hostility. The chilling effect is too great. Anyone who wants to speak against these donors can make the substantive case for their point of view. The only reason they need the donors' names is to go after them and chill them. That's less speech, not more.
All right, with that, and I'm going to apologize. You know, I should have known that a discussion this robust would deserve opening statements longer than 2.5 minutes. So I have allowed, I actually stopped you both about the same time, so that Professor Tepker is now fully aware of the time he has. You are welcome to take 5 minutes and 5 seconds for your opening statement. So.
Well, first of all, I want to thank you for having me. And second, I want to express my admiration for your belief in miracles. A miracle here is defined as expecting a law professor to confine himself to a time limit. We're not trained to do that, and we rarely do. I think my viewpoint is going to be a little different than those already expressed, although I think we view the law as it is pretty much the same way. The answer to the question, does the First Amendment protect donor privacy, is yes. But, and this is where the key qualifications come into play, it is not an absolute protection. It is not a comprehensive protection. As Andy has suggested, it may not be as strong as Clarence Thomas would like. What happens... Well, that's one way to
just move it,
cut off discussion.
Move it a little bit closer, I think you'll...
Okay.
I think it's the Lord.
It's the Lord? Okay. I didn't know I'd said anything blasphemous yet. The protections, I think, are roughly described as a form of balancing. And to borrow a phrase from Mr. Churchill, balancing is a very bad way to interpret the Constitution, except all of the others, which are so much worse. Balancing is unpredictable. Balancing is subjective. Balancing takes into consideration a wide variety of circumstances, but it doesn't leave protection as absolute as we might like. Still, with that said, I would pretty much endorse the status quo and the balance is struck by saying this. When legislation attempts to exert a content discrimination or a viewpoint discrimination over core political speech, protection is at its highest. That is where scrutiny is truly exacting. And I think that's the situation that was presented in the McIntyre case and the Tali case and some others. I share endorsing the tradition of the anonymous pamphlet or the anonymous newspaper column such as those prepared by Mr. Madison and Mr. Hamilton in the Federalist Papers. The Supreme Court respected that tradition in those decisions, but it did not do so with a view that there should be strict scrutiny. Instead, the court noted that some regulations are not directed at certain viewpoints or certain philosophies, and there should be a lower level of protection, a different kind of balancing. And I agree with that. I agree with the statement in Buckley versus Vallejo that sometimes the public needs to know who is participating, who is aligned, so that they can make appropriate evaluations of the political alliances in existence at the time of an election campaign. And here's the important point. Most of our First Amendment jurisprudence is devoted to public discussion. Robust, uninhibited, wide-open public discussion, but public discussion in public forums. In that context, I do not think there should be all that much concern for intimidating the Koch brothers or Mr. Adelson from participating in presidential campaigns. If there is a body of data suggesting there's a chilling effect on their contributions to candidates in recent years, I haven't seen it, and I will express to you my own point of view. I don't believe in it. I do think there are occasions, though, for the individual employee in a local community, the person who wants to write a point of view, their dangers are very real. And the dangers are very real in NAACP versus Alabama, as Andy rightly pointed out. But that is not the common situation. We must distinguish between the threats and the chilling effect that comes from governmental action and the threats and the chilling effect that come from private rebuttal, dismay, anger, emotion. The national commitment to robust, uninhibited, wide-open debate sometimes requires those of us with a point of view to express ourselves courageously. And the government should not be in the business of protecting against all such hazards. That's probably an unseemly or uncomfortable solution because it's messy, it's unpredictable, it's a incomplete protection, but I think it's the one that's most consistent with our system of free expression, the system of free expression created by the Founding Fathers. I also want to point out that to the extent we get into more energetic protection of the privacy of donors, we're using a concept, privacy, which is pretty difficult to define. All you have to do is read the Griswold decisions and the substantive due process decisions to see that privacy is not an easy thing. And the totality of Supreme Court judgments in this area, I think, tends to prove what George Bernard Shaw said. An American doesn't know what privacy means, doesn't have a sense of privacy. I think privacy is the wrong word for those cases. It tends to be a kind of autonomy in certain kinds of issues. So I don't think you're going to find privacy as a very useful legal concept for protecting more free speech. I think the dangers to our system of free expression are really rather different, but I won't press beyond the 5-minute limit to go into that subject.
Well, that's good. Now we will go to Trent for your opening statement, sir.
Well, thank you, Jonathan. I'm going to agree with Professor Tepker and then disagree with him, which is I think that I think it is absolutely right to say that privacy is a challenging word to use because it means so many different things to different people. But I think the founders gave us, actually, James Madison in particular, gave us a better construct in the actual drafting of the First Amendment, right, which is Congress shall make no law. I mean, the First Amendment is more strongly worded than I think we often give it credit for in a debate like this. The question is not, is government going to step in and help people remain anonymous? The question is government going to step in and use its power to prevent people who want to remain anonymous from doing so? And I think we have to accept that there are contexts in which anonymous speech is not possible, and there are people who, even in a system, even in the system I'm going to advocate here in just a moment, where government does not compel disclosure, there are people who will wish to remain anonymous and fail to do so. Perhaps because of the enterprising efforts of their political adversaries. But that is a completely different question than when government action is involved, and not just I, but the unanimous Supreme Court in the NAACP opinion that Professor Spiropoulos mentioned disagrees with Professor Tepker on his point about not attributing state action when it is the response of the community that a person is concerned about. Here's what the court said, and I think this is absolutely right. It is not sufficient to answer, as the state does here, the state of Alabama in this case, that whatever repressive effect compulsory disclosure of names of petitioners' members may have is in petitioners' activities follows not from state action but from private community pressures. The crucial factor is the interplay of governmental and private action, for it is only after the initial exertion of state power, represented by the protection order demanding that the NAACP turn over its member list, that the private action takes hold. I think this is absolutely correct, and I think that I actually will make an even stronger argument, which is I think that this fascination with disclosure, which I once sort of shared, it's easy to say, well, let's just disclose everything and not worry about it. And I in the past, before I'd really thought this through and looked at some of the actual historical examples, I thought, oh, that's a fairly tenable position. But I think if you look at the effect on our politics of our infatuation with disclosure, it is that it has shifted our debate more and more away from the ideas expressed and toward this assumption that no one even acts on ideas in politics anymore. It is one of my frustrations with the media is that so often political stories are reported as if no one believes anything. They simply act as automatons representing their donor base or their interest groups, and the opposite is almost, not always, but almost always the case, which is that donors flock to candidates with whom they already agree. Right? Agreement is the precondition for support, and I think that disclosure is actually a part of the problem with our politics today. Surprisingly enough, it has left us fascinated with all these connections between people and ignoring the debate. And this is what the American founders understood. The reason for Publius, the reason why Madison, Hamilton, and Jay, and so many others wrote under an assumed name was because they didn't want the arguments to be about themselves. They wanted the arguments to be about the ideas. And so not only do I think we have all of the risks of government pressure and of government intentionally exposing other people to public pressure that we've talked about here today, but I think the added risk is that the more we force disclosure, the more, we essentially in our politics have said, where we endorse disclosure, that there's something inherently corrupting about people associating together. And I think that is, in some cases, true, but I think in most cases it is false. And I think it has put us in a position today where we start not giving our political candidates and political actors the benefit of the doubt, but we start assuming corruption and then expect people to prove the opposite. I think that is corrosive to a democratic form of government. And I think that the American founders were right. I think Clarence Thomas is right. And as Professor Spiropoulos said, he's really the only justice who takes this view. But I think it's absolutely correct that we have swung the pendulum far too far in favor of compelled disclosure, compelled speech. And I think we should go back to the NAACP case as our guide in a different direction.
With that, I think that leads us into a good next question. I think I'll start with Professor Tepker. I'm going to read the question, and the debaters feel free to address back some of the discussion that's already started, so feel free to take the freedom to do that. In what we just talked about, I think a good question that we've all, the group considered is, right now, most donors to nonprofit organizations are allowed to remain anonymous. This includes organizations involved in public policy debates, get-out-the-vote activities, and issue advocacy. Does the law, either state or federal, need to change to require disclosure of these donations? And as a follow-up to that question, does the U.S. Constitution provide any protection for these donors to remain anonymous? Start with Professor Tepker.
Well, when preparing for this debate, I did what the other gentleman on the panel did, I think, go directly to NAACP versus Alabama, which is a great, historic, and correct decision. But what it says, in an opinion by Justice Harlan, is that there shall be balancing. There shall be concern both for donor privacy, or in this case, the membership list of the NAACP, but also concern about consequences in governmental interests. And in that case, the governmental interests were thought to be non-existent. But let us be candid. This is the late 1950s. It's Alabama. The story could have also been told in Mississippi. These membership lists were being used as hit lists for various organizations opposing civil rights efforts. And it posed an enormous problem that is a great American scandal, and the Supreme Court did the right thing. Now, it may be said that the same thing is happening in California, although I must say, based upon the stories that have long since become a part of American history, I don't think what's happening in California is reasonably comparable to what was happening in Alabama and Mississippi between 1957 and 1965. I could be corrected on that. But in any case, it's all submitted to a balancing process. So the answer to the question is yes, there is some protection. The protection is incomplete. And no, I don't think we've turned away from NAACP versus Alabama. We don't need to go back to it. It's part of the process that exists. That said, I think I need to point out that there are other aspects and other stories we can tell if we're going to argue anecdotally. Recently, there was a West Virginia case in which the Supreme Court set aside a state Supreme Court judgment in a multi-million-dollar tort action because the owner of the company that was the defendant had practically provided all of the money to the judge supplying the decisive vote in overturning the verdict. Well, that's the other side of the story. That is the example of the inherently corrupting process. Now, we can set a different rule for judicial elections. I understand that possibility. But we needed to know. We needed to know that man made the contributions. The people of West Virginia needed to know. It is the potential for actual corruption that gives the public interest behind disclosure laws. Turn them into absolutely protected private operations, and there is no telling what problem will go on. I prefer the status quo, which is NAACP versus Alabama, a balancing test. I do not favor absolute protections that will prevent government from looking on the internet or looking on contribution lists or trying to investigate legitimate law enforcement concerns. That's how an ambiguous term like privacy, amplified with absolute principles and exacting scrutiny, can establish real obstacles to pursuing the public interest. So I admit to my skepticism that there's great need for any dramatic change.
Let's go next to Professor Spiropoulos. Would you like to interject at this point on that question?
Thanks. Well, I want to say, or I could scream really loudly. We're going to note this for the historical record. I actually largely agree with Rick, certainly in terms of the...
Please get that down. Everybody make a note.
I actually do agree that that there has to be a certain level of balancing, which you have to understand about the First Amendment. And this is very difficult for originalists and even more difficult for textualists, is that the text and original meaning of the First Amendment really don't actually help us interpret the First Amendment. It really is, the extent to which we have First Amendment protections, it's largely been a common law process in which the court has elaborated and needed to the rules regarding how speech is protected and how far. And so there's always going to be a certain level of balancing, no matter how rigid or black and white the court wants to articulate the rules. So, for example, I've already said, even though I believe the level of protection should increase, that maybe shareholders really ought to be able to know if their corporation is level of donations. If you're a shareholder of a corporation, that really should be disclosed to you. I might be willing to have a distinction between large donors and smaller donors. These are kinds of the things that would be considered, right, as we go through these. But it really ought to be exacting scrutiny, because when we're talking about political donations, it is content discrimination. You're focusing on a particular content of speech. And so I think what we're talking about here is how tough it needs to be. And so the right question, for me at least, given the way the court deals in this area is what legal regime, what set of rules would lead to more speech across the board for everyone. And I think it's up to the court to craft a set of rules that will lead to that while also protecting other interests, such as that of shareholders, for example. Dealing with the question of quid pro quo, corruption, direct contributions to candidates. These are the things the court can do, but it needs to think more seriously about the real problems that are occurring of coercion, of people getting involved in politics. And one last point, Rick said earlier, the Cook brothers can take care of themselves, that's true. But I want to point out, right, how bad it is for our politics to focus on the identity of people with points of view, to say we're going to disagree and hate these people because of who they are, and to disqualify, and not on their message. And here's what's going on with the Cook brothers. Criticize their politics all you want, but it's gotten so bad that now there's pressure, right, on the charitable organizations. They are, by the way, among the biggest funders of cancer research in this country. They are major funders of the cultural institutions of New York City. I don't know if you knew that. There is now pressure in New York City for the museums of New York City not to take the money they've taken from them for decades. They've literally built wings because of who they are. That's insane, right? That's insane. And it's all about not wanting to argue on the issue. Instead, to disqualify people. And it goes on both sides, by the way. It's not just one side. To disqualify people because of who they are. That's pernicious. And if the Supreme Court can do something to help prevent that, I think they should.
Professor Blitz, what's your view?
Okay. I'm not sure how much of I agree it's insane. We might all, I think that might be something we all agree on. I wonder, though, how much of the insanity it's the responsibility of courts applying the First Amendment law to fix. There are a lot of things, there are a lot of problems in the political life of this country, in the cultural life of this country, that it's not going to be on the courts to fix. In fact, it would be stretching the Constitution too far for them to try to use a Bill of Rights provision to fix a problem that's not a Bill of Rights problem. So part of the question is when you look out at the problems that arise from disclosure, other problems in political debate, how much of these get addressed by First Amendment cases? So let me, I'm not sure we're really responding to the question.
You're
okay. Let me make a proposal for how to separate an easy from a hard case when it comes to disclosure law, okay? If the court looks at a government disclosure requirement where it makes someone disclose their identity in speaking, and there's very powerful evidence, and maybe NAACP is this case, that the reason the government is doing that is not to educate the voter. The reason the government is doing that is really to try to make the speech less likely to occur or to make the people who are speaking suffer. But because it can't do that directly, the First Amendment stops it from arresting them for their speech. It cleverly decides to simply expose them for their speech and then let private thugs do what the government can't do. I think if you can identify cases like that, where a court can draw that conclusion, that's an easy case, right? That's a case where the analogy I think of is if a military attack is going on and someone is supporting the attack, not actually engaging in the use of weapons, but is shooting a flare so that the attackers can see, that's what the government's doing, right? It's like shooting a flare by requiring disclosure because it then knows other people will respond by attacking. But the clearest reason that that's a problem is that the government motive makes that a First Amendment problem. The government's motive is to suppress or punish speech. It's a bit more complicated when the government is requiring disclosure, and it might have that effect. It might be the case that, although this isn't the government's intent, that by forcing people to disclose their identity, bad repercussions will follow. Then the question, though, is, well, okay, what should be the framework for that? Where the government is not attempting to silence speakers, not attempting to make them suffer. It has reasons, actually reasons that are somewhat, are at the very least legitimate, maybe even stronger than that. For requiring disclosure, people need information. And one of the side effects of that, one of the unfortunate side effects, is that because society is the way it is, if you go back and read John Stuart Mill's On Liberty, right, he obsesses about private punishment of speech, the fact that people will react negatively to unpopular speakers. Well, what should the court do about that? To what extent should the court say, well, government, we know you're trying to do the right thing by disclosing identity, but you're burdening speech, so you can't do it. There are a whole range of circumstances, I think, where the court says, well, it's a burden, but without the motive of suppressing speech, we're going to be very tolerant. It's not just about disclosure requirements. I mean, anytime there's a discussion about how to design the internet, right? There could be an unintentional, it could be an incidental burden on speech. It could be a burden on speech the government knows is coming, but that's not its reason. I think in that circumstance, I don't know if I'd call it content neutral because sometimes the government might be focusing on election speech, but it's not doing it to suppress speech. And I think in that circumstance, I'll tell you, there's been an evolution in my views, and I'm not going to give you the whole story. But I used to be much more in favor of courts sometimes, maybe often, playing sociologist and trying to understand exactly what's going to happen. I'm much more worried about that now. I'm worried about judges trying to be empirical political scientists, social scientists. And so I think, and I think this echoes some of Rick's comments, that I think that where you don't have a government motive, there should still be some showing. But I think that calling it exacting scrutiny is just misleading. That's not what's happening. And my current position now, although maybe by the end of the debate it'll change, is that it shouldn't happen. That it just can't be the case that government is going to burden speech all the time. And there are certain times that, last thing I'll say, that even where the logic is, yeah, we want to give the audiences the identity of the speaker because that's important, I think sometimes intuitively that's exactly right. And I'll give you an example, maybe I'll change my mind. If foreign governments are putting lots and lots of money to try to influence American elections, I don't think it's a terrible thing that people know that that's happening, what the source of it is. It doesn't mean that they should just entirely ignore the message, although many people will inevitably do that. But I think that in that case and other cases, it's important for people to have cues that shouldn't open the door to harassment of the kind that occurred in NAACP. Certainly not intentional government harassment, and in some circumstances, even where government isn't aiming for that, people should still get protection from it.
Trent, go ahead.
Well, I agree that judges shouldn't play sociologists, but I don't want them to play psychologists either, and trying to determine what the motives are of the government unless that's absolutely necessary. I think one of the silliest things that Justice Scalia has ever written was in one of these cases where he, dealing with anonymity, where he writes, why would judges step in? We have all these elected officials, and they balance these things out. And why would we step? They know how the political process works far more than we do. And for sure, that's right. They know, the class of incumbents know that how electoral politics work, and they know that their incumbency is worth a good deal of campaign dollars, right, is the equivalent of a good deal of campaign resources, right? And so anything that they do that maybe sort of incidentally makes people less likely to support their challengers benefits them as a class. It's kind of like in the area of redistricting. I think these are two areas where we have a real problem in our politics because incumbents have an interest that rises above party and above all of the dividing lines we typically think of. And this is, in redistricting, you have the majority and minority party candidates can easily conspire to make all of their districts safer. And in this case, the incumbents in Congress can just happen to support laws that make it harder for people to challenge them. And I think that asking what the government's interest is, or looking for sort of an improper government motive is the wrong question. I think there is a balancing test here, but the question is, does the government regulation, in this case disclosure requirements, is it actually, exacting scrutiny is the right test. Is there actually a compelling government interest? Is this necessary? And I will come, I guess, sort of to the Koch brothers' defense in this sense, that they own major corporation, multiple major corporations, right? And one of the things talking with some folks from different parts of the world about repression in other countries, one of the interesting things that you realize is that in a country without a powerful organized government, like I was talking to someone who was in Kazakhstan. Government repression is very easy to see. It's kind of like Alabama in the 50s, right? They come and they beat you and they try to kill your family. And it's very easy to see that. I was talking with someone who used to live in China about repression there, and she said, well, repression in China, they don't come and beat you. I mean, they have, government controls the housing market, and government controls the job market, and government has all these controls basically everything, right? And so you don't really see it. They don't even admit it, right? But as government gets bigger, that's what happens to oppression and to repression. It becomes much harder to recognize. And I think that as our government has gotten bigger, it is very legitimate for people to be concerned about whether it's the biggest donors, the Tom Steyers and the Charles Kochs, or smaller donors, to be concerned about those kind of reactions to their political involvement. And it's stifling not just speech, but stifling political association, which is what the NAACP case is about.
All right. With that, so to bring this home a little bit personally, I've got 2 more questions, and so I'm going to limit our debaters' response time to about 2 minutes each. That way we have some time for audience questions. But considering state, local, or federal action that may be taken regarding either political donations or donations to nonprofit organizations. For a person that takes the deduction for their mortgage on their tax return, for someone that may be concerned about the slippery slope, what would be the difference between protecting the ability to donate to a nonprofit organization and that anonymity for an individual, and the difference from protecting the anonymity of someone that might use a mortgage deduction from the IRS code? And Professor Spiropoulos, you want to start with that question?
Well, right now there is no difference, right? They're treated the same. So if you donate to a 501c3 charitable organization or religious organization, cultural organization, then that's protected. It's also protected if you give to a 501c4, which tends to be more involved in politics. The question is really that's coming up is whether that should change. I think, and that's something we haven't talked about very much. I think what's looming, right, in the background of all this is the desire. I know the president has this desire. And a lot of people in Washington on the president's side who want to change our current disclosure requirements so that if you give to an organization, don't want to get too deep into the tax, but it's a 501c4. They don't necessarily give to a candidate directly, but they're involved in politics. They give money to run issues campaigns, right? If the president and his party had their way, those contributions would be disclosed, right? We wouldn't be treating it like a 501c3 anymore, a regular charitable contribution. And say they had the votes in Washington to do that, and the election comes out their way. Do we think that's constitutional? 2 years ago, I would have said probably yes. Now I say no. And for me, it's because maybe it just took a while for me to just sink in because I'm slow. Once you make the decision, frankly, not in Citizens United, but in Buckley, that money is political speech, you accept that principle, then you accept the principle that speech can be anonymous. then how do you not protect the anonymous donation the same way you protect other forms of anonymous speech?
Professor Tepker, what are your thoughts?
Well, Andy and I are agreeing so much, I have to figure out some way to disagree with him, and it won't be very basic here, but money is not political speech. Nevertheless, a quantitative limit on money contributions in a campaign is a quantitative limitation on the quantity of political speech. I think the soundbite misleads, but it also helps explain the answer to the question. When someone contributes in an expressive association financially to an effort to communicate an idea, they're engaged in what I think has to be characterized as both expressive activity and non-expressive activity. And I think plenty of cases which say that same behavior can be both expressive and non-expressive in certain elements. The reason I go through that is the tests are different. If you're engaged in expression or expressive activity, the standards of justification on the part of the government are quite high, quite demanding, quite tough, and they ought to be. But when we're talking about associations to engage in non-expressive activity, then the tests become more deferential. Then there may be reasons to treat that as conduct, not speech. Now, you can tell just from this oversimplified introduction that it can be quite devilish to apply those tests in real life. But roughly, this is what I would say. The First Amendment has been very good, very settled, very acceptable, very effective in saying we cannot censor ideas. We cannot impose criminal punishment for the expression of certain ideas and viewpoints. And I now think we have a consensus, at least on this panel, that we should not have government-imposed limits on the quantity of information devoted to political themes associated with the campaign. That is the meaning of Citizens United and Buckley and the rise of cases. I do want to admit, though I agree with that result, though I agree with Scalia and Thomas about it, there isn't anything originalist about this. This is all an example of a judicial elaboration and exposition of a value that's present in the Constitution at the time the 14th Amendment and before that the First Amendment are ratified. But these principles bear no resemblance to anything James Madison is thinking or talking about. And yet we're enthusiastic about them. Well, how does that all apply here? I think what we need is a legislative accommodation, not a judicial micromanagement, to balance all of the different considerations, including motive, including the motive of the speaker, including the public interests. And that's not easily done in a few phrases, certainly not within a 2-minute time limit. But more is possible. And I just don't believe that, I basically agree with the idea that Andy described earlier as one he once had but doesn't have anymore. I'm in favor of the idea that campaign finance limits should be governed by one standard, and that one standard ought to be the exacting scrutiny standard that applies to independent expenditures and actual campaign spending. But disclosure is appropriate, because sometimes the people need to know if there's a corrupt West Virginia mine owner who's financing an election campaign. And that seems to me to be an element of an appropriate balance.
Trent.
Well, it's an interesting debate because I get the sense that all of our views have changed over time, notably. And as I said before, I used to be very comfortable with disclosure. One of the things that this whole conversation has reinforced to me, that I sort of already come to this conclusion, is, I mean, if this all really works the way it was just described, why don't we just ask candidates to tell us if they're corrupt? Why don't, I mean, wouldn't that just be a better form of disclosure? Let's cut right to the chase. I mean, the West Virginia case is sort of an outlier, right? I mean, most political corruption cases involve someone selling or buying a house different from market value, or letting the congressman live rent-free on his boat, or what have you, right? They're not. You don't typically find corruption by going through the disclosure reports. You might, but. No matter what we do in the area of disclosure, the real intentional corruption is always going to be at least one more layer in, right? I mean, that's what we're talking about here. Now, I do think there's a concern about bias, and I think it's important to point out, when I'm making an argument that maybe sounds slightly stronger than I'm intending, there is a concern, I think, about people who say they're Secretary of State, just as an example, and their husband is collecting $500,000 speaking fees from foreign governments. That is a case where there might not be actual quid pro quo going on, but it's hard not to see that and think there could easily be bias. And one of the concerns that the founders had, I think they were much better at talking about than we are today. We always talk about sort of intentional corruption, is the fact that the person who is most deceptive deceives himself first. Right? The person who is most deceptive is the person who thinks that they're doing the Lord's work, but they have over time perhaps become, their perception has become skewed because of who their friends are, who their campaign donors are. I do think that when it comes to people who are actually elected to office, I think that disclosures, financial disclosures, certainly knowing how much money they raise and from how many people, I mean, I've asked myself whether that would simply be enough. How much money did you raise, and from how many people did you raise it, to give sort of an idea, and voluntary disclosure. Certainly there are groups out there that voluntarily disclose things because they say, we think this builds our credibility, right, in the political marketplace. But I think we have to be careful about this idea that somehow by compelling disclosure, that just, then we're going to see all of the corruption, up there on the billboard. That's not how it works, and we actually know, when we think about it, that's not how it works. We should design a system that really gets at the corruption that has as little an impact on speech and association, and I think, well, I'll save it for my closing, my last thought.
Professor Blitz, what is your thought?
I think I'll try to keep it short right now, which is just to say, I'm not sure what the answer is. I'm a little bit worried about anything that's not just balancing, but free-form balancing, where I think I don't like the idea of calling the test exacting scrutiny, and then what exacting scrutiny is, actually, when you kind of unpack it, is the government has to have a sufficiently important interest. Who knows what that is until courts figure out what they consider sufficiently important, and there has to be a substantial relationship. Again, that's all very vague. So I'm not sure what the right, if you're going to take the position that yes, you have a right to speak anonymously because being forced to reveal your identity burdens your speech, but it can't be absolute because there are times government, or maybe others, have to know, then what's the right middle ground? I'll just sort of throw out one thought. In the context of defamation law, there's a difference between the way public figures are treated and the way private figures are treated, right? Public figures will have a much harder time winning a defamation case because they're public figures. And in any case, there are sometimes questions arise about whether that's right, but the idea is they put themselves out there, and therefore they're more able also to answer criticisms. Maybe courts should be tolerant of a legislative regime, and this harkens back to some of what's been said, which will allow people who make small donations and really aren't, they want to just contribute to an effort, but they're not Sheldon Adelson, and they would otherwise, they don't want to be hearing from people simply because they're supporting an effort. I think legislatures should probably be able to protect their anonymity. That involves playing sociologist a little bit, but maybe in a more straightforward way. For others, I think, audiences might, there are other reasons, including the appearance of corruption, but also audiences might use the source of the identity as at least a first cut judgment, and I don't think that's terrible. And particularly if the entity that, or person who has to disclose their involvement is perhaps more like a public figure. That's just a thought.
All right, so what I want to do is now allow for, I'm going to take 2 questions from the audience. That way then I can allow our debaters to give closing statements. I believe the mic in the center of the room is hot. This is going to be one of the rare cases where you can actually ask a law professor a question and not worry about being disrobed intellectually. I hope.
My name's AJ. It's actually not hot.
Oh, sorry.
But I can yell if you'd like.
Okay, yeah, please. Oh, wait, I think we got some help right there.
They are suppressing my speech, but they've turned it on now. My name's AJ Ferrati. I'm actually an attorney that practices in this area from time to time, and I thank you for this presentation. It's been interesting and helpful, and glad that the dialogue is going on. My question is really along the lines of kind of stretching this a little bit. I'm going to take the Attorney General of California as the example here. She has developed this process of investigating significantly deeper than anybody else in the country, whereas she's even going to third-tier donors into independent expenditures that have no significant contact with the event or activity in the state of California, and investigating them and trying to bring them to light for certain issues. Assuming, for example, that we are in agreement with California that we need to have some disclosure around independent expenditures, how far does that need to go? Do we go back 3 and 4 tiers? It's just kind of an open thought to the panel.
I don't know. I don't know of principles. If someone is abusing their investigative power by going too far, there are mechanisms, sometimes inadequate, to restrain that kind of investigative misconduct. I don't know that she's guilty of that, but I don't know how to give a global answer to that.
The only thing I'd say about that is that maybe, if you're going to keep the current framework, but tinker with it or fix it, maybe that requires a closer look at a kind of more active judicial questioning when it comes to the government sufficiently important interest standard. Because if they're really just using investigative powers and the claim of possible corruption or possible fraud as a pretext, I think you'd want courts to ferret that out. Now, that may involve playing psychologists sometimes, but actually there I've been convinced, I think I used to take exactly that view on courts playing psychologists, that at least courts have to sometimes look skeptically at what the government claims its interests are. This isn't what this panel's about, but for those of you who think about commercial speech, it did this in the Sorrell case, where it does this sometimes, where government says, of course we have a great reason for doing this. And actually, as the court starts to explore its reasons, things look fishy. And I think there's no way around courts doing that sometimes in First Amendment cases. And maybe, again, I'm not going to take, I'm not familiar enough to say that there's power being abused, or I don't know. But where there is, then I think courts might say, no, you've said there's a sufficiently important interest. That's not what there is.
I think that the other similar situation, in my opinion, is what's gone on in Wisconsin with the John Doe investigations, and I think that's where, to me, it bolsters my case for a much brighter line versus a balancing test, and trying to steer back toward Congress or via the 14th Amendment, states shall make no law that impinges on freedom of speech, freedom of association, freedom of the press, which the point I was going to mention before, I mean, really, I think it's the history of the idea of freedom of the press, which informs the understanding of freedom of political speech in the First Amendment, because freedom of the press at the time of the American founding, well, I mean, the press was a rich guy with a printing press and a political point of view. Right? I mean, that's what the press was. It was organized political speech, and you had to have a lot of money to make it work. I think that I think in the end we will know, in my opinion, from what I have seen in California, this is my suspicion. I think it's pretty clear in Wisconsin that the intent here was to suppress political enemies. I just don't like I don't like a test. I'm not comfortable with a test where we have to wait until the damage is done and then go back and weigh the intent of the government actors. I think that we need a regime. I think the point of the First Amendment, I don't think we have to import this back into the First Amendment. I think the point of the First Amendment was to not allow us to get to a place where we have to sit there and decide whether California's Attorney General has bad intent or not.
I know we're short on time. Very quickly, it's an excellent question. How does this come up? Right now, if you're a political action committee, you've got to disclose your donors. But what happens is you've got nonprofit corporations who give. They give to the political action committee, and that's what you disclose. So you disclose this nonprofit corporation, and so what they're trying to do is hunt down those people, right, who gave to that nonprofit corporation, right, because we want to know who gave the money. And my point is, like, if it's not a direct contribution to a candidate, why can't they just remain anonymous, right? This is where clarity in principle solves the problem for you. They have a right to stay anonymous if they're not directly giving to a candidate, right? The principle is very simple. And the underlying corruption of our politics is this need to find out who our opponents are so we can destroy them. And that's the problem.
With that, one more question for the audience, or we'll go to closing statements. All right. Why don't we start with Trent and work our way? Well, I'll scatter it. Never mind. Go ahead, Trent.
Okay. Well, a couple of points. How long do we have for closing statements?
Let's try to limit it to 3 minutes.
3 minutes. So I'll lay out a couple of things that weren't that we haven't mentioned so far, but that I think get at one of the larger issues here, and that is, it was mentioned. I think Professor Tepker mentioned the First Amendment as a protection against criminal prosecution of speech. One of the problems that we have with the entire Bill of Rights, but I think it bears on this question, is that it is correct that the Bill of Rights is largely about government investigating, prosecuting, and punishing crimes, because the administrative state did not exist when the Bill of Rights was written. And one of the things that governments have done, whether legislators or administrative agencies, is discover that in some cases, if they don't criminalize something, they can go after it and avoid or at least limit the restraints imposed on them by the Bill of Rights by going after these things in civil or administrative proceedings. And in some cases, the penalties are worse than the penalties in criminal law. And in every case, the threshold of proof is lower. And I think this is one of the meta issues when we talk about this. This is an administrative framework created to govern political speech. In the case of Wisconsin, as far as I know, all of the impropriety alleged, which it looks like is going to turn out did not even happen, but it's all violations of these rules. Right? It's not violations of any malum in se crime. It's violations of these rules. Government creates these rules and then says, we suspect you may have violated these rules, so we're going to investigate you and expose you. And the Wisconsin. If you're not familiar with what's gone on in Wisconsin, this is the strongest case since the civil rights era for exactly what we're talking about here today, for protecting people's anonymity and for understanding that government, whether it's the federal government or right down to the level of local county prosecutors, is subject to abuse. And what we need are bright line rules to protect us against that abuse. I if you leave here and do one thing, if you're not familiar with the John Doe investigations in Wisconsin, look these up. I mean, it is horrific nighttime raids on people's houses because they're alleged to have communicated with the people they were supporting in politics. It's absolutely outrageous. We should have bright line rules. I think that's what the First Amendment was designed to provide us with.
It was impressive. That was under 2 minutes and 30 seconds.
I'm a radio host. I have hard breaks.
I'll try to do less and fail, but I will try. One of the best books on the First Amendment jurisprudence is called The Worthy Tradition. Because Rick is right. The First Amendment was intended to keep the federal government out of the regulation of speech and to protect state establishments. The text and history of the First Amendment don't tell us very much today about what the First Amendment means, because it was meant to do something completely different than we've been using it for the decades. What the Supreme Court has done in a Burkean common law way is to elaborate principles, to engage in dialogue with the political branches, to try to say, yes, it is your job to try to establish the best legal framework for speech, but there are principles that we all agree on as a society, and there's experience that we have as a judiciary through elaborating these principles that can enable us to help you to get this right, to maximize the level of speech. And in this area, right, they already have the core principles in place and have had it in many ways since 1958. We protect anonymous speech. We protect, to some degree, to a great degree, right, speaking through the giving of money and the spending of money. We have these core principles in place. It's about elaborating the best legal framework in dialogue with states do. But I think we can start with cases in which we all agree, right? I think we should be able to all agree that it is simply wrong, right, when dealing with someone who wants to remain anonymous, for the state to make the affirmative decision to facilitate by forcing these people to disclose what they do not want to disclose, their name, the address, the amount they gave, so that other people can mine that data, right, and chill them from speaking. We should be able to agree that that's a problem, and that the Supreme Court, through the elaboration of the worthy tradition, should be able to find some way in dialogue with government to protect those people and allow that speech to take place.
So the part of that I completely agree on, and I've already said this, is that when it's clear that they're doing it in order to chill, when the government is forcing disclosure of information in order to chill speech, and there's evidence, I think that's an easy case. The tougher case is when they claim that there's an interest in forcing disclosure of information, they're not intending to chill speech. What do you do about that? One of the reasons I think that that's difficult is that, although this was mentioned, maybe we didn't dwell on it enough, if you think about the logic, right, why is it that your right not to identify yourself is protected by the First Amendment, right? You still, as the justices say, Justice Scalia, who's one of the biggest critics of a right to anonymous speech, at least in elections, on the court says, you know, if you understand why does the First Amendment protect this, I think the best explanation is that in most cases, it's not that anonymity is speech. It's that being forced to surrender it burdens speech. It's only one of many ways, though, that government can burden speech. And when government is burdening speech in some other ways, and just to give you an example of how it can burden speech in all kinds of ways, right? If money is speech, I think it's kind of easier to say treat money as something, as a resource that aids speech. Because if money is speech, land is speech also, right? Land is sometimes a resource that you need to put a sign up, to hold a protest. So land use laws, any law that regulates your use of land, or your use of government land, can burden speech. And as it turns out, the court has developed a very complex set of doctrines about, well, certainly use of government land. It's called public forum doctrine. We'll save that for another debate. And it's really complicated and very heavily criticized by scholars, although I don't know that that means anything. We'll have to criticize everything. But so the question is, right, when government is not intentionally suppressing speech, but is just regulating, trying to regulate corruption, or trying to force information it feels people need to make intelligent decisions, what should be the baseline when they're not trying to suppress speech? I think I'm still for a fair amount of protection, particularly for, as I said earlier, the little guy, right? For people who otherwise would feel, you know, they don't want to suddenly be attacked from all sides. But I don't think that you need anything like an absolute or close to an absolute right to anonymous speech. You don't have an absolute right against other kinds of non-intentional burdening of speech.
My views have also changed over the years. In my wayward youth, I was an enthusiast of privacy. I thought the government should be kept out of bedrooms and boardrooms and classrooms, and privacy was one of the greatest concepts to American liberty. When you actually work with the practicality of cases, however, you discover that privacy is a very uncertain concept. So in addition to the Wisconsin case, the West Virginia case, the California case, let me tell you about one case that probably contributes to my bias in this area. I worked for Clarence Thomas. Clarence Thomas appointed me as professor in residence at the EEOC, and one of my tasks was to prepare for his approval and that of the EEOC generally, a brief to be submitted to the Justice Department in a case involving the University of Pennsylvania. The University of Pennsylvania had been accused of discrimination, racial discrimination, gender discrimination, and they were asked to submit the information surrounding the victim, the alleged victim, her tenure review file, the tenure review file of those male candidates who had received tenure, and which were the basis of a legal claim that she'd been treated differently than they. And the university responded, as many do, accusing the government of misconduct, of trying to suppress speech. They called it academic freedom, but what they were really saying is privacy. If you expect us to hand over the files and include that with the donations, the donors of confidential peer evaluation all around the country, it will be a chilling effect. We won't get candor. We won't even get voluntary cooperation. The Supreme Court considered that argument, that academic freedom-based concept of privacy, and reached a unanimous decision. And that unanimous decision, which was an opinion by Justice Blackmun, basically amounted to laughter at the University of Pennsylvania. Their position was mocked and caricatured, and rightly so, because all the university wanted to do was to hide its proceedings from an investigation to find out whether there had been discriminatory intent and discriminatory attitude. Now, the point of this was that the Supreme Court didn't use phrases like exacting scrutiny or balancing or deference. What it said was this: these issues were far removed from content discrimination, far removed from trying to control what the university taught or who the university would choose to teach. And because the claim was so attenuated, because the chilling effect claim was so attenuated, they found there was no case. Now, I'm not saying that that presents a paradigm that answers all the questions here, but it is a case that has to be brought into the mix. Sometimes it's not government trying to suppress speech. Sometimes it's even universities, academics, scholars, the best of all people, trying to pull a shroud over their operation so they can behave like a fraternity. We know about fraternities now, don't we? I think privacy is a very uncertain concept. We should be very skeptical about it. We should adopt the vantage point of Burkean conservatives and resist absolute principles and resist the idea that everything should be reduced to a simple formula. We should be skeptical about the claims of privacy in these kinds of cases. Thank you.
Well, with that, would you join me in thanking our debaters today? Thank you for your time. Please pay attention to OCPA's website, and we hope to do these more often. Thank you.